Good afternoon, my name is Lisa Nunn and today I'll be presenting Assessment 2 for ATI140. When Australia was colonised by the British in the 18th century, there was no recognition of the pre-existing land rights of the Indigenous people who had occupied the land for tens of thousands of years. In the 20th century, laws began to be introduced to recognise these rights that had previously been ignored. It's these legal A number of different legal mechanisms exist around Australia for Indigenous peoples to make claims on land. Federal legislation was introduced in the 1990s, but because it took so long for this to come about, most states had their own land rights legislation before federal legislation was introduced. This map shows land claims that have been made through different state and federal laws. The coloured areas are those claimed by Indigenous people under state-based systems, while the grey areas are those So first of all, I'd like to look at the federal legislation that applies across Australia. The Native Title Act was introduced following the High Court's decision in the Mabo case that native title did in fact exist in Australia. This allowed some Indigenous people to make claims for land they had not previously been able to claim under state law. The Native Title Act may grant Indigenous people rights to access land, hunt and fish on the land, conduct ceremony and take spiritual responsibility for the land, camp or live on the land in some cases, However, the Act has some serious limitations. It does not grant ownership of the land to the claimants. Since there is no grant of freehold title, the claimants have no right to exclude other parties from accessing the land, and, although they should be consulted about development, they have no right to stop any developments going ahead. Native title is also considered to be extinguished by the prior grant of other titles or certain types of leases by the government, so no claims can be made over residential land, commercial land or agricultural leases. This, in effect, means claims are restricted to vacant Crowned land. In addition, claimants must prove continuing, unbroken connection to the land they are claiming, and this creates serious problems for those people in areas that were settled early on, which have been dispossessed of their land for many. In the Northern Territory, we have the Aboriginal Land Rights Act. 38 years prior to the Mabo decision, the Gurindji people, led by Vincent Lingiari, walked off the job in Wave Hill Station in protest about working conditions and the occupation of their traditional lands by European settlers. The support and public awareness that grew out of this action eventually led to the NT Aboriginal Land Rights Act being passed in 19. Unlike the Native Title Act, the Land Rights Act does grant freehold title. This means that Aboriginal people receive true ownership of the land. They have the right to control access to their land and can refuse development if they wish. Nearly 50% of the Northern Territory is held as Aboriginal freehold land under the However, the Land Rights Act cannot apply to land within town limits or pastoral leases. In addition, the communal nature of the title can make it difficult for Aboriginal people to access credit in order to develop economic enterprises. Looking at another state now, in Victoria, the Traditional Owner Settlement Act is the most recent piece of legislation, which was created after the passing of the Commonwealth Native Title Act. Prior to this, there was no standardised claims process in Victoria, but on 6 occasions, land had been transferred to Aboriginal people through the creation of specific pieces of legislation. The Traditional Owner Settlement Act was developed in consultation with the Victorian Traditional Owner Land Justice Group. This process began after the dismissal of the Yorta Yorta people's land claim, highlighted the difficulties of satisfying native title criteria for Victorian traditional owners, most of whom had been displaced from their land long ago and thus did not have the continuing, uninterrupted connection to the land required by the Native Title Act. The TOSA allows for a range of settlement packages. They can include recognition of traditional owner rights, grants of freehold land, funding agreements, and land use activity or natural resource agreements, which involve traditional owners in how their land is used and managed. This is a progressive piece of legislation that has allowed for more land claims than would have been possible under the strict parameters of the Native Title Act. It also allows for the grant of freehold title. However, if a claim is made over public land, the claimants So, how does New Zealand systems compare with those in Australia? New Zealand provides an interesting comparison with Australia because of a number of similarities. New Zealand too was a British colony, settled not long after Australia, and like Australia, its colonisation by the British has led to ongoing conflict between Europeans and Maori and a decline in the Maori population. But there is, however, a major difference between the colonial history of the two countries. Unlike in Australia, in New Zealand, the British colonists signed a treaty with the country's prior inhabitants. About 540 Maori chiefs signed the Treaty of Waitangi with the British Crown in 1840. The treaty was an agreement to form a nation-state and government in New Zealand. It made the Maori British subjects and gave the British Crown exclusive rights to buy any land the Maori wanted to sell. The Maori retained the rights to their land and sea and their resources. But there are a few discrepancies between the English and Maori versions. The Treaty of Waitangi should have protected Maori's rights to their land and sea and the accompanying resources, but in the ensuing 135 years, the treaty was wildly violated by the British colonists. In 1975, the Waitangi Tribunal was established to hear claims by Maori of treaty violations by the British Crown. At first, the tribunal could only accept claims of present-day treaty violations, but this was changed in 1985 so the tribunal could investigate historical violations right back to the date of the treaty's enactment. The tribunal provides 3 kinds of redress to the claimants. Historical redress involves giving an account of, acknowledgement of, and apology for breaches of the treaty. Cultural redress can include the return of land, an establishment of shared governance of land and sea, or changing place names, and can take many other forms as well. And there is also financial or property compensation. About half of the tribunal members are Maori, and each tribunal panel must have at least 1 Maori member. The tribunal also has a role in removing contemporary prejudice and Some limitations of the Waitangi Tribunal are that once a claim has been settled, no further claims by that claimant group can be considered. Since the tribunal is a separate entity from the government, it can only make non-binding recommendations which the government can choose not to accept. The settlement itself is handled by the Office of Treaty Settlements. The New Zealand government conceded early on in the process that it could not afford to compensate the Maori properly for their losses, so financial compensation is modest and symbolic. And in some cases, the cost of running an organisation needed to manage the settlement may negate the financial compensation received. So how do Australian legal frameworks for land claims compare to the New Zealand system? A few things obviously stand out from New Zealand that are improvements on the Australian system. A 2014 report from the Cape York Institute for Policy and Leadership identified significant benefits in the Waitangi Tribunal process. The tribunal provides the forum for grievances to be aired and acknowledged, gives a formal apology, promoting healing and closure so that the claimants can better move on into the future. The Waitangi Tribunal releases reports to the public that set the historical record straight and formally acknowledge the wrongs that were done. Analysis of past wrongs is something Australia has generally shied away from, and Australia's land rights and native title laws do not include this reconciliatory process. Australian new laws are more narrow in their focus compared to the broad scope of the Waitangi Tribunal, dealing only with legal recognition of Indigenous peoples' rights to land itself, without considering this as part of a bigger picture. Other forms of compensation or recognition are not covered. For example, New Zealand now recognises that Maori have a claim to a portion of all of New Zealand's fisheries, something that would be difficult to establish in Australia. New Zealand also does not have state-by-state laws to navigate, but rather one national process which ensures equal consideration for everyone. Mandated Maori tribunal members mean Maori claims are given consideration by their peers, and it's not just white people deciding about Maori's future. There are some very important differences here. In Australia, more Indigenous involvement in decision-making is urgently needed, as is a process by which past wrongs are openly acknowledged. Australia would do well to take notice of New Zealand's leadership